Hello. In this video from Justia webinars, David Kemp, adjunct professor at Rutgers Law School and former legal writing professor at the University of California, Berkeley School of Law, discusses the craft of legal writing, how lawyers can improve their legal writing skills, and why writing matters. If you want to see more Justia videos on law practice and legal marketing, be sure you're subscribed to our channel.
Welcome to this California CLE webinar. Today we're going to cover how to write like the best legal writers. On the agenda for today, I'll introduce myself and then I'll focus on how we can write like the best legal writers, looking at three in particular. In conclusion, we'll cover a few extra resources in case you're interested in further reading, and then I'll take questions at the end. So let's start with the introduction. My name is David Kemp. I graduated from Berkeley Law and am currently the managing editor of Justia's Oyez and Verdict. I'm also an adjunct writing professor at Rutgers Law School, and I formerly taught legal writing at Berkeley Law. While I was a student at Berkeley Law, I was a senior executive editor of the California Law Review. And in these roles, I see all sorts of writing by practitioners, by academics and judges, elected officials, and of course, students. And I see essentially three levels of writing competence: poor, passable, and strong. Poor writing contains objective errors, grammatical mistakes, typos, and so on, and usually is a product of insufficient writing or editing time and a lack of knowledge or skill. Passable writing contains few objective errors, but writing style is just incidental. For example, there may be organizational issues, poor flow or transitions, superficial conversation, such as, you're talking in a foreign language that you don't really know that well. You can talk about the weather and other things, but you can't engage in those deep, meaningful levels of conversation that have several levels of meaning. And strong competence has no objective errors, makes deliberate style decisions such as word choice, sentence length and sentence order, structure, and big picture organization. So how do we go from one level to the next? How do we go from poor to passable, or from passable to strong? Besides spending more time on the writing, which sometimes we have the capacity to do, and sometimes we're constrained by our resources or by hiring it out, we can read and emulate strong writing to become stronger writers ourselves. So let's look at how really good legal writers do what they do. That's what we're going to focus on today, is looking at strong writing from nearly universally acclaimed legal writers. So I've broken down the tips for today into a few things that I think are sort of universal. So regardless of whether you're writing an appellate or a trial brief, a judicial opinion, perhaps even communications with clients and colleagues, whether you're writing for law journals, blogs, websites, whatever, I think that these principles will improve your writing regardless of what type of writing you're doing. There's certainly far more techniques, but they're beyond the scope of what we can cover in 1 hour. So based on my experience teaching and doing writing, these 5 stand out as being particularly helpful in improving writing. And to visit these techniques, we're going to use 3 different vehicles for learning. I've chosen 3 passages by 3 of the most renowned writers: Justice Elena Kagan, the late Justice Antonin Scalia, and the late Justice Robert Jackson. So I've chosen actually 3 dissenting opinions, in part because I feel that the dissents, or through the dissents, their individual voices really come through. And in fact, the Scalia and Jackson pieces are both lone dissents, whereas Kagan's is joined by 2 other justices. So just as a preview, in case you're not familiar with these cases, in the Brnovich case, Justice Kagan lamented the majority's decision in Section 2 of the Voting Rights Act, In the Morrison case, in Scalia's dissent, Justice Scalia is criticizing the majority for undercutting executive authority by permitting the appointment of independent counsel. And in Korematsu, Justice Jackson is criticizing the conviction and detention of a Japanese-American man during World War II, or leading up to World War II. So the reason that I chose these three, and in addition to these justices being so revered for their writing, is that they really reflect a lot of experience and education and process in writing. Each of these justices, or especially Justice Kagan and Justice Scalia, have talked extensively about the writing process and how much time it takes. And that's one of the keys here is to spend the time both in the writing process, but also the editing after you've written. Justice Kagan is sometimes recognized as the best writer ever on the Supreme Court. Princeton, Oxford, and Harvard trained. In an interview with Brian Garner, Kagan said, "The most important thing in a brief is clarity." And her writing really exemplifies clarity. Justice Scalia, we all know also as a really highly regarded legal writer. He went to Georgetown, Harvard Law, and he's known for his biting wit and precise writing. He actually co-authored 2 books with legal writing guru Brian Garner, including Making Your Case, The Art of Persuading Judges. And Scalia says, know your audience. So advocates hinging on his vote knew, for example, not to press arguments based on legislative history or policy. And finally, Justice Jackson is often cited as one of the best writers in Supreme Court history, including by a majority of the current sitting Supreme Court justices. So that speaks a lot to his regard and as a legal writer. So let's look at how to write for a non-lawyer audience. Writing for a non-lawyer audience is really important, even if your audience is actually a lawyer, because it's easier to read, it's easier to comprehend. So the ways that you can do that, the 3 things that I think are easiest or most accessible for writing for a non-lawyer audience is to avoid jargon, define legal terms of art, and use examples and analogies. As Kagan says, focus on clarity. And does this conflict with what Scalia says, know your audience? If you're writing for a lawyer audience, does writing for a non-lawyer audience conflict with Scalia's advice? And I would say, no, it doesn't. So even in areas where I consider myself well-versed, clear and simple, but not pedantic writing is far more enjoyable to read. And something that's more enjoyable to read is easier to comprehend. So let's take a look at one of the examples. In Brnovich, Justice Kagan writes, "If a single statute represents the best of America, it is the Voting Rights Act. It marries 2 great ideals, democracy and racial equality, and it dedicates our country to carrying them out. Section 2, the provision at issue here, guarantees that members of every racial group will have equal voting opportunities. Citizens of every race will have the same shot to participate in the political process and to elect representatives of their choice. They will all own our democracy together, no one more and no one less than any other." So let's look at some of the techniques that Justice Kagan uses here. First of all, the sentences are very short. She uses simple phrases, simple words, and this is the beginning, so she starts very broadly. She's talking about the Voting Rights Act in broad terms, not this precise statutory language yet. And one of the things that this accomplishes is it brings the reader in. It makes it very accessible for the reader, and she's giving us the direction of the opinion that she's going to take us. Let's look at another example here. This is from Scalia's dissenting opinion in Morrison v. Olson. Scalia writes, "That is what this suit is about, power. The allocation of power among Congress, the presidents, and the courts in such fashion as to preserve the equilibrium the Constitution sought to establish, so that a gradual concentration of the several powers in the same department can effectively be resisted. Frequently, an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident and must be discerned by a careful and perceptive analysis. But this wolf comes as a wolf." One of the things that Scalia does really effectively in this passage is he juxtaposes very long and complex sentences with much shorter sentences. But this wolf comes as a wolf, carries the emphasis of a very short sentence to conclude that paragraph, and starting the paragraph with another short sentence, two of them actually. That is what this suit is about: power. It's hard to get more clear and more direct than a sentence like that. He also effectively uses this metaphor of the wolf and the sheep, a metaphor that most of us are very familiar with and something that relates what this issue is about in a way that's very accessible for us. Finally, Justice Scalia talks about not just what this issue is, which he does, it's about power, but also he talks about what this issue is not. And sometimes describing what something is not about can help clarify what it is. Finally, in Korematsu, Justice Jackson writes, "Korematsu was born on our soil of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim is made that he is not loyal to this country. There is no suggestion that, apart from the matter involved here, he is not a law-abiding and well-disposed. Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born, and where all his life he has lived." And in writing this way, Justice Jackson draws us in to understand Korematsu's story, who he is as a person, because that's the focus of his opinion. That's what his opinion turns on, is how can we deny the civil rights to this person simply by who he is. The second tip is to build a story arc. To build a story arc, you should start with a big picture overview. Repeat keywords and phrases to signal relatedness between paragraphs and sentences, and conclude with the highlights and takeaways. In coaching people to do public speaking, one often says, tell them what you're going to tell them, and then tell them what you told them. And the same thing holds true in writing. So let's look at a few examples of how these justices do that in their writing. In Brnovich, Justice Kagan writes, "If a single statute reminds us of the worst of America, it is the Voting Rights Act, because it was and remains so necessary. Because a century after the Civil War was fought, at the time of the Act's passage, the promise of political equality remained a distant dream for African American citizens. Because states and localities continually contrived new rules, mostly neutral on their face, but discriminatory in operation, to keep minority voters from the polls. Because Congress had reason to suppose that states would try similar maneuvers in the future, pouring old poison into new bottles to suppress minority votes. Because Congress has been proved right." Justice Kagan uses the word "because" 4 times in a row, ending with the strongest and shortest one. And what she does over the course of this paragraph is to explain why a single statute reminds us of the worst of America. She starts big, she starts abstract, and then explains why that first sentence is so true, ending with, "because Congress has been proved right." She follows this arc of a story, starting with something broad and then explaining it further and further, using repetition to draw those sentences together to arrive at the culmination of this whole paragraph, that Congress has been proved right. Here's a tip that we often see Scalia not do, but it's still worthwhile to investigate, and that is to use shorter sentences and smaller ideas. So studies have shown that shorter sentences are easier to understand. Readers understand at least 90% of 14-word sentences, but only less than 10% of 43-word sentences. So the shorter your sentence can be, the easier it is to understand. And also, focus your paragraphs on a single topic. More focused paragraphs are easier to follow. And we saw that in in all of the previous examples that we've looked at, the writers are really focusing on a single topic in a paragraph and then transitioning to another paragraph. Let's see what Justice Jackson has to say about that. He writes in Korematsu, "But the law which this prisoner is convicted of disregarding is not found in an act of Congress, but in a military order. Neither the act of Congress nor the executive order of the president, nor both together, would afford a basis for this conviction. It rests on the orders of General DeWitt. And it is said that if the military commander had reasonable military grounds for promulgating the orders, they are constitutional and become law, and the court is required to enforce them. There are several reasons why I cannot subscribe to this doctrine." Some of the things that Justice Jackson does here, again, is saying what this is not. He says, it is not this. This would not work. Only that, and let me tell you why. And so the way that Justice Jackson puts all of this together really makes this a compelling story. It uses these shorter sentences. It rests on the orders of General DeWitt. There are several reasons I cannot subscribe to this doctrine. Those are the sentences Justice Jackson wants us to pay most attention to. They are the shortest sentences, and they're the most emphatic. Our fourth point is to eliminate passive voice and wordiness. So just as a review, passive voice emphasizes the object and de-emphasizes the subject. For example, if you said a new rule was proposed by the EPA, that's passive voice because the emphasis is on the rule, but the action is actually by the EPA. The action is to propose. In contrast, the EPA proposed a new rule is the active voice. The EPA is the subject and the one doing the action. The new rule is what action was acted upon. Use passive voice deliberately and sparingly for the purpose of emphasizing the objects and de-emphasizing the subjects. Most of the time, active voice is superior to passive voice. It uses fewer words and it's more direct. Let's look at Justice Scalia using active versus passive voice. The major fortification provided, of course, was the veto power. But in addition to providing fortification, the founders conspicuously and very consciously declined to sap the executive's strength in the same way they had weakened the legislature, by dividing the executive power. Proposals to have multiple executives or a council of advisors with separate authority were rejected. In the first part of this paragraph, Justice Scalia used the active voice. The founders conspicuously and very consciously declined, the focus of this sentence being on the founders declining. The sentence that follows de-emphasizes the founders to put the emphasis on the rejection of proposals. Proposals were rejected. They were rejected by the founders, but Scalia has chosen to put that sentence in passive voice because he doesn't want to emphasize that the founders were the ones who rejected the proposals. He's emphasizing that the proposals were rejected. This last tip is to finalize your writing by reading it aloud. And many of us don't have the luxury of time to be able to do that. But when you do read aloud your work for the purpose of doing editing and proofreading, you'll notice awkwardly long sentences and be able to revise them. You can catch minor typos and correct them. You can also address tongue twisters and mouthfuls. One of the things that you want to keep in mind is even though the product that you're delivering is written, if your writing is pleasing to listen to, it will also be pleasing to read. And especially when you're writing for a judge who is skeptical to begin with of your position, perhaps, who is busy, you want your writing to be easy to read so that your arguments are easy to digest and understand, and your side is easy to favor. Let's take a look at Justice Kagan using this. This court has no right to remake Section 2. Maybe some think that vote suppression is a relic of history, and so the need for a potent Section 2 has come and gone. But Congress gets to make that call. Because it has not done so, this court's duty is to apply the law as it is written. The law that confronted one of this country's most enduring wrongs pledged to give every American of every race an equal chance to participate in our democracy, and now stands as the crucial tool to achieve that goal. That law, of all laws, deserves the sweep and power Congress gave it. That law, of all laws, should not be diminished by this court. Now, when I hear this passage, it sounds very much like President Lincoln's Gettysburg Address. That law of all laws should not be diminished by this court. Lincoln said, that government of the people, by the people, for the people, shall not perish from the earth. What Justice Kagan here is doing is invoking the way these words sound. This sounds like someone invoking action. I almost guarantee that someone in Justice Kagan's chambers read this passage out loud at some point because it's so poetic, it's so beautiful, and it's so rhythmic. Of course, not all the briefs or memos or letters that we write can be poetic, but reading out loud the words that we're writing on the page can really signal to us how the reader is perceiving them. And we can elevate our writing by thinking about it, hearing it ourselves, and writing it so that it can be listened to. Let's take a look at the way Justice Scalia implements this. The ad hoc approach to constitutional adjudication has real attraction, even apart from its work-saving potential. It is guaranteed to produce a result in every case that will make a majority of the court happy with the law. The law is, by definition, precisely what the majority thinks. Taking all things into account, it ought to be. I prefer to rely upon the judgment of the wise men who constructed our system, and of the people who approved it, and of 2 centuries of history that have shown it to be sound. Like it or not, that judgment says quite plainly that the executive power shall be vested in a president of the United States. Again, the way that Scalia writes here is nearly poetic. He excoriates the other justices, the court, for taking this ad hoc approach to constitutional adjudication, saying we must rely on what the founders originally intended. And of course, we know that Scalia says this in different ways in many different places, but the way he says it here is rhythmic, it flows, and it sounds like something that is supposed to be read aloud. Finally, let's take a look at Justice Jackson's writing in a way that can be heard. My duties as a justice, as I see them, do not require me to make a military judgment as to whether General DeWitt's evacuation and detention program was a reasonable military necessity. I do not suggest that the courts should have attempted to interfere with the Army in carrying out its task, but I do not think they may be asked to execute a military expedient that has no place in law under the Constitution. I would reverse the judgment and discharge the prisoner. So here, again, Justice Jackson is calling to the reader to hear his words. And he's using this repetition that we talked about, shorter sentences, what is not, to really emphasize his point that is not the role of the military or of the courts to uphold the conviction of Korematsu here. So I'd like to conclude by just pointing you to a few other resources that reiterate a lot of what we said, but also go beyond what we've covered in this webinar today. Several of the points here come from various resources. Ross Guberman's Points Made is an excellent book. It's in its 2nd edition, and he pulls, in a similar way to what we did today, he pulls from some of the strongest brief writers across the country at all levels of the courts, and points out passages or entire paragraphs or even pages from their briefs, pointing out what they do so well and why it works. He divides it into numerous chapters, focusing on a different theme in each one. It's very accessible, and the way that it relies on examples, I think, is a very effective tool for anyone who writes persuasively, because it really demonstrates using examples what works well and what works less well So I strongly encourage you to refer to that book if you ever have to write persuasively. A second book that's very helpful is Brian Garner's The Winning Brief. Brian Garner is probably the legal writing guru. He's interviewed basically all the justices about writing specifically. He's written all of the major authorities on legal writing, and it's a really excellent brief, a really excellent book about persuasive writing again. And then taking a step back from persuasive writing specifically, there's this other book by Armstrong, Terrell, and others, Thinking Like a Writer, A Lawyer's Guide to Effective Writing and Editing. I find that book is an excellent resource as well, not just for persuasive writing, but for any kind of writing. It breaks things down into bite-sized pieces. Again, uses lots of examples to illustrate how things work well, what makes things work less well, and it has exercises as well to let you practice improving your skills. So that's all great. But for those of you who don't have time to study up and practice on the excellent prose of the great legal writers of yesterday and today, there are some tools that make it easy to improve your writing. I'd like to talk about 3 tools in particular: the built-in spell check and grammar check in Microsoft Word, a web-based tool called Grammarly, and the newest technology that has recently been in the headlines, ChatGPT. Now, these aren't a substitute for a skilled human writer and editor, but they can definitely help you improve your written product. So let's first look at Microsoft Word's spell check and grammar check. So anyone who's ever typed a document in Microsoft Word is probably familiar with its spell check and grammar check tools. Spell check has been a feature of Microsoft Word's word processing program since the early 1990s, but it's evolved significantly since then. Originally, you would have had to affirmatively run the spell check and grammar check, which would then review your document for unrecognized words and strings of words that seem to violate the rules of grammar as they were encoded into the software. That was great for catching some typos, but if your mistyped word was simply a different word, such as statue instead of statute, early versions of spell check would not catch that. But over the years, we've seen it evolve and improve. It checks as you type, indicating objective errors with a squiggly red underline, and frequently offering relatively high-quality suggestions for fixing word choice, passive voice, and other issues affecting readability. It also fixed the statute versus statue problem and others kind of like that. But even with these advances, it still cannot replace the work of a strong human writer and good editor, particularly when it comes to big picture techniques like the story arc and the complexity of ideas that we talked about. So let's look at a slightly more sophisticated tool. Let's have a look at Grammarly. So Grammarly comes a little bit closer. It started in 2009 as a web-based grammatical error correction tool, and it quickly became popular among students and professionals across industries because of its speed and adaptability. Grammarly uses cutting-edge technologies now, like natural language processing and machine learning, to offer suggestions not just for incorrect words or misspellings, but for full sentence rewrites, tone adjustments, consistency, and readability. And again, while Grammarly cannot replace a human editor, it definitely helps weak and average writers refine their skill not by merely suggesting changes the way Microsoft Word's tool does, but explaining those suggestions as well. In fact, I use Grammarly for myself for all documents that I produce, student assignments, professional correspondence, and more. And I also recommend to my students and colleagues that they use Grammarly for all of their written products. I view it as one step above spell check and grammar check, and it continues to improve and get more sophisticated and more precise in the way it suggests improvements in writing. As an educator, I also use Grammarly for a neat feature that allows you to check for duplicate content. This can be an effective tool for checking for plagiarism, but for content creators, it can also help ensure that your content is sufficiently unique for SEO purposes. And that brings us to the most advanced writing tool, and one that is a hot topic in the news right now, ChatGPT. So ChatGPT is a chatbot launched by OpenAI in November 2022. You can ask it to perform countless tasks, which it executes almost instantaneously. And among these tasks, for our purposes today, is the drafting of various documents. So let's see how it performs. In this case, I asked it to draft a cease and desist letter regarding the unauthorized use of copyrighted material. If you look over this letter, it looks okay, it's not bad. It seems to be pretty good at drafting these form letters like this one. But for anyone who sends these types of letters on a regular basis, you probably already have your own templates that's far better than what ChatGPT can produce. So let's try something a little bit more nuanced. In this instance, I asked it to draft a 500-word blog post for a law firm website describing the Supreme Court's decision in Ariano v. McDonough, which was decided in late January. It did a terrible job. It gets the facts and the issues completely wrong, and while some of the statements are correct, such as what the Equal Protection Clause is, which I did not include in this excerpt, overall it completely misses the mark. You can see the OIA summary in contrast. It talks about completely different legal issues. The mechanics of the writing, however, are impressive. If we ignore the substance, we see that it starts with a general conclusion, it then goes in to provide some background, and then explains the significance of the decision. So the words, the sentences, the paragraphs all flow smoothly, and it employs a number of the techniques that we discussed in the first part of this webinar. So it's not about to replace me as the editor of OIA anytime soon, but unlike the other two tools we looked at, it can generate content from scratch rather than simply checking or improving something that you or someone else wrote. And I expect to see huge advances in its factual accuracy in the near future. Here's another example. And this time, I asked it to draft one paragraph of marketing language for a personal injury law firm. And having written and read more of these than I can count, I can say that ChatGPT did a really good job with this task. I dare say that this is better than what I've seen on a lot of law firm websites. And finally, let's see how it does with a legal question. In this instance, I've asked it an ethics question that the State Bar of California's Committee on Professional Responsibility and Conduct recently addressed in an ethics opinion. What ethical obligations arise when a lawyer represents a client whose case is being funded by a third-party litigation funder? As you can see, and if you look closely and read carefully the parts that I did not include here, its answer pretty closely tracks the digest that the committee itself wrote. Both identify confidentiality and independent professional judgment as the main ethical issues. So what does all this mean for attorneys? Right now, ChatGPT is not going to replace a human writer when it comes to documents that require factual knowledge, but it seems to be pretty good at rule-based analysis and writing. Now, I think that it can be a helpful tool, at least as a starting point, for some types of documents and writings because of its ability to quickly produce writing that follows generally accepted norms for effective communication. Substance-wise, it has a long way to go, and there are some fascinating ethical issues with technology that are beyond the scope of this webinar. But I would encourage all of you to take ChatGPT for a test drive to see how, in conjunction with spell check, Grammarly, and your own human eye, you can become a more effective writer. So that's it for today's webinar. Thanks for tuning in. If you have questions, you can reach me by email, on Twitter, LinkedIn, and so on. Thanks so much.
We hope you enjoyed this video. And if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.